Daily list for motion, item 1.
May I please, your lordship?
Yes.
May I please, your lordship? Lordship, petitioner's name appeared in the voters list of 1966, page 68. Serial number 101. 69 is the relevant portion. One zero one.
Yes.
Subsequent voters list.
Yes, Lordship may send it back, Lordship.
Sorry.
Otherwise, tribunal rejected the claim of the petitioner on the ground that Sobitullah and Soritullah are not same in one person, Lordship.
How does the tribunal know it is not one letter?
Lordship, because
If
as
the
per
tribunal has
Lordship,
given a finding, what
Yes.
is the material before the tribunal that Soritullah and Sobitullah are not same? They have to give reason also.
reference was in tribunal, as per tribunal, Lordship, reference was made against Habibullah, son of Sobitullah, but document placed
I
before.
know,
Yes.
we have understood it. What is the material before the tribunal to arrive at a conclusion that Soritullah and Sobitullah are not same? Was there any material? Then
Lordship, send it back.
why should we send back
Yes,
if this man is there? You had your chance, you did not take it. Even if to arrive at a conclusion, you need material, you have to give reason. It's not your whims and discretion that I don't accept it. Find out, we'll take up after some time. Ask your SP, does he have any material that these two people are not same?
Then next week, Lordship.
Not next week, today after some time. Ask your SP, maybe me to inquire. Give me a photocopy of this voters list
To read.
and ask him whether these two are, according to him, is a different person.
And in fact, Lordship, may I submit? In fact, in the inquiry report itself, they have stated, the referring authority has stated that he may not be a illegal, and
Yeah,
so
that
he's
is
not a
another-
foreigner.
That
Yeah.
has no meaning of its own.
Yes. Otherwise, I have documents 66 onwards, same place, same village, and the person has passed it both.
What about the earlier one? Sorry.
Lordship may take the, those which Lordship is taking in other matters, the SP may conduct an inquiry and place the inquiry report before this court.
The superintendent of police border of Dhubri district to make an inquiry and submit a report before the court as to whether Saritullah, father of Habibullah Sheikh of the voters list of 1966, and Sabiullah, who is the father of the petitioner, are two different persons.
We'll place the report in 2 weeks.
List next week for the report.
Lordship, 2 weeks. Normal course, Lordship, they are also burdened with
They are not burdened.
10 days.
They are the
Lordship.
least burdened office possibly in the
Lordship,
government
they
of.
grant us 10 days time, Lordship.
They do have to do only 30 reference a day in a month and nothing beyond that. So how can you say this office is burdened? SP is burdened. We would have definitely taken note of, but not SP border.
Lordship, 10 days.
How did
Again, Monday is again a holiday, Lordship.
Coming Monday is not a holiday.
I
Then
think
this
it's a
report can actually be given by
Something-
tomorrow also, Madam Verma.
Sorry, Lordship,
If the person works, it can be given by tomorrow also.
can be Lordship.
So one
Keep
week is
it for
good
next
enough.
week, Lordship.
It's good enough.
Copy of this order may be served on me.
List on three. It's disheartening to note that the tribunal, without any material of its own, had rejected a claim by petitioner that Saritullah and Sabitullah are not 2%. Tribunal to also show cause as to why such conclusion was arrived at without any reasonable material.
9th May. Item 2,
Lordship,
A copy order to
Lordship,
Mr.
on
G.
earlier, in this case, Lordship, earlier occasion,
Other one, you asked a tribunal also, why without any material, you just reject it? Did not tribunal not have a further duty? Suppose it that comes to its mind. Make an inquiry and tell us, did it not have a minimum duty? Instead of rejecting, could the tribunal not done a step forward? Ask the Home Department to please go and verify whether these two persons are same or not. Instead of straight away rejecting.
Lordship, this plea ought to be taken in many
No.
cases. With the tribunal, Lordship, maybe they do not go that
These
extra
small
step.
trivial
Yes,
matters,
Lordship.
have you noticed the expenditure that is incurred on the state exchequer because of this small mistake?
I understand. Lordship.
Somebody is, has to be responsible. Very well. It is possible that Saritullah and Savitullah may not be the same person, but that requires an inquiry.
We apprise the Lordship.
That is what requires an inquiry. Mhm.
nine.
No, let them tell the reason why. The land council came for a tribunal to inform the court as to why the tribunal did not make any further inquiry. If there is no material. So who's gonna like it?
My lord,
Yes.
in this lordship earlier, there was direction to inquiry lordship. Report. The report.
Inquiry not
See,
yet
even
visible.
when the matter is before us,
Yes, Lordship.
when we cannot arrive at a conclusion either this way or that way, don't we ask for some further material? We definitely ask. Suppose on the existing material, it is difficult to take a call either this way or that way. We always make a request that please make an inquiry, bring us some further material before us. Even we are not taking a call either this way or that way. Same is with the tribunal. In fact, it is more so in respect of the tribunal. We are at least having a complete material before us. Tribunal is in the stage of procuring material.
In this case, Lordship, inquiry.
The
report is not
admission
yet
register of
received.
the school contains the name of sub. But in the entry containing the name of Sabia Khatun, there is use of, it is difficult to read as to what was the original letter, something or something.
School admission register. Yes, Lordship. Yeah, not yet received, Lordship.
The report as required to be submitted by the Superintendent Police Border Kachar is stated to be not available today. This so and so for the report.
Problem.
item 3,
May I please your lordship? My lord, lordship, 1966 voters list of father and mother in page 84, lordship. Haran Mondal. Golabjan Nessa Bibi.
Page number 84,
Yes, lordship.
electoral roll.
And lordship, Kabinnama was exhibited.
So Haran Mandal is the father
Yes, lordship.
and petitioner is Lobiron. Yes, Ahiron. Lobiron or Ahiron? Why alias?
Labiron.
Why an alias?
Because in some places our name is written as Abiron,
What's the actual name?
Labiron.
Where is the Kabin number?
Kabinnama is at
Page 90.
page 90, lordship.
Abiran.
Kabin number is Abiron.
Abiran.
Abiron.
So Kabin number will be right.
Yes.
You
lordship.
never have a marriage certificate with a wrong name.
Yes, lordship.
Voters list may contain a wrong name, but a marriage certificate will not contain a wrong name.
Yes, Abiron.
Hmm. Now the petitioner is Abiron or Labiron?
Abiron. Abiron. Abiron.
Abiron.
Yes, lordship.
What is the actual name?
Actual name is Abiron. Abiron, lordship.
From where did Labiron come from?
In voters list, in some voters list, it's Labiron.
No, you were relying only on your father's voters list and the Kabin number.
Yes,
Not
lordship.
relying on the other voters list.
Yes, her voters list is Labiron.
The notice is, to whom the notice is issued?
Notice is issued. It's
Abiran.
Abiron. It's in reference also Abiron.
This is Abiron.
Abiran.
Yes, lordship.
What to do?
Page 35, lordship.
Page number 30,
35, third para, lordship. On that ground, Kabinnama was rejected, lordship.
35.
Yes.
What
Page
is,
third para, lordship.
we're not interested what the tribunal is of the view. On the materials on record, what is your submission?
And
If the notice is issued to Aviron, Aviron produces a Kabinnama
Yeah.
saying that Haron Mandal of Mayaswar is the father.
Yeah.
And there is a voters list of Haron Mandal of 1966 of same village. So you just examine whether it is same or not.
Yes, lordship.
it's duly proved. DW7, Montaz Ali, to prove Kabinnama also was
Who is
present.
Montaz Ali again?
Montaz Ali is the Qazi who appeared to prove this Kabinnama.
Kabinnama has to be proved.
Yes,
In
How can
Nokta,
Montaz Ali prove a
Yeah.
Kabinnama?
LD
from,
assistant.
yes, from Qazi's office authorized.
Montaz
Because,
Ali is authorized by the Qazi office.
yes, lordship page. Evidence of DW7, lordship.
He is Montaz Ali. Montaz Ali is only a
Yes.
cousin. He is not
Uh,
somebody from the office of the Qazi.
I am the office bearer, page 79,
What do you mean by office bearer?
at Qazi's office.
What do you mean by office bearer?
He has brought the register also, marriage register. From
But
that,
is he authorized?
I was appointed by Qazi. Qazi himself has not gone. He has,
How can he
Sir.
appoint?
the general practice is there, but I have seen also in doing in the trial court. Like if you issue summon to the circle officer, he will assign that work via an order to his office to appear and to adduce evidence.
So from tomorrow, if I start delegating my power to,
This is
will you be content?
I understood, Lordship. But
So in the morning, 10:30 will come, I'll just sign a delegation order.
he brought the records, he
Understand.
himself, yes, Lordship,
They'll also have the record with them.
but they are not in a constitutional post.
So what is the difference between a constitutional post and a non-constitutional post for the purpose of discharging the duties of a post?
Because this,
Is there a reasonable classification? That constitutional post, you have to do it yourself, non-constitutional post, you can go and delegating.
to an order, because sometimes in the regular practice is going on in the
I
trial.
know, we
Yes,
are,
their circle officer or
no,
deputy
we are
commissioner,
questioning it. Why
Yes,
the
Lordship.
circle officer cannot come?
they are not coming.
Even
they are
this
assigning to
affidavits by
that.
the government, we find, we require the secretary to give, they'll give it to some other secretary, go and file an affidavit before the court. Delegation পারে যান নির্ভর করিব ইমান। If the document is a private document.
Only thing is that the contents,
Only the custodian can. তো কোনো কথা নেই, তাহলে কাজই নেই। How many office bearers are there in the office of the cousin?
but I have to verify, Lordship, I,
Are all the cousins of the proceedings office bearers for the respective proceeding? Say for your case,
yes, Lordship.
Monta's cousin is the office bearer.
No, he is not the cousin.
You said your number
No,
7
no.
is cousin.
No, number 7, I didn't say, I said office bearer of the Qazi office, not Qazi, Qazi's office.
Okay, Qazi's office bearer.
He is not the cousin.
Lordship, may remand back the matter for examination of Kazi Lordship. Not the
Again, the
appeal,
records, because she has to bear the cost. Already with the records, they have come before the tribunal. Bring the marriage register book and index book. He has
No,
brought all these documents.
She says that this man is actually a official from that office.
He may be like Lordship has just said, when there is a personal appearance, if Lordship directs me to appear, I
But there
can't
is no person appearance.
But the summon was to the Qazi Lordship. The Qazi ought to have appeared. These things ought to be taken
Let
seriously.
me check the
because-
records, because sometime in the notice, it's written personally or you.
It may not be personally, summons.
In
She's a-
someone only, I have to just check it out, Lordship. What
Someone
was-
is whosoever is summons has to come.
Yes. Usually the practice is going on in the tribunal, they assign their junior staff to appear.
See the notice of summons to the Qazi.
The whole thing is so conveniently done up Lordship from both the sides, even on the government side and even on the petitioner's side. Whichever process it suits them Lordship, it's taken up, but then the whole procedure is gone for a toss now.
And why can't the Qazi come? If he is holding a public post, he is also answerable to the court summons also. Otherwise, he should, if he is so busy a person, he should not hold that post. He can appoint some other Qazi. How many marriages are conducted every day by one Qazi?
I have no idea.
Yes, Mr. Sigdar. One Qazi will conduct how many marriages in one day? On the average, one Qazi, he will conduct how many marriages?
I think there is no limit, man.
Unlimited marriages in one day.
my lord. A number of marriages, my lord, in a year, my lord,
per day.
per day.
I don't think it will be more than one. On a given day, there may not be any marriages also. So many marriages take place over.
That may be, my lord. There is no clear cut, my lord, and there is a binding.
Everybody knows we are asking on the average.
Lordship, there is an order by the Muslim marriage registrar, subject to the assigning reason thereof, Muntaz Ali, son of so and so, of it, hereby appointed as LDA office. He is the LDA office bearer of Anchalik Muslim Marriage Registered Office. He shall have all the office work by the instruction of District Qazi. There is an office order
No, to whom the summons is issued?
that I'm checking. Lordship. Election officer.
If the Qazis are not responding, let us issue one non-bailable warrant to one of the Qazis for defying the warrant, summons.
Someone to one, I will check for this one. Because there is someone to buy, so notice to the election officer I got. Seriously, my. Yes. This is a different. You see, no, Abija, he is not Abija. Abija. This number 1443. What is this document then? What is her case number? Case number?
Is the law of delegation applicable in respect of summons? Madam Verma,
Sorry,
is the law of delegation applicable in respect of summons?
I do not know, Lordship.
Mhm.
There is another notice of some other case also here.
Maybe in this case, we don't know, we just in general proposition we are asking. Find out, we'll take up after some time.
yes, Lordship, I'm
And,
going through the records.
Madam Ghosh,
Yes, Lordship,
law of delegation flows from the concept in administrative law.
yes. Delegation of power.
Huh. The legal concept of delegation, its source is administrative law. It is not CPC or CRPC. When a summons is issued to X, it is X alone who can come. Or X will make an application that he is inconvenienced in any matter. Please dispense with my appearance. The same evidence can also be led by a different person.
Usually they send an office
Yeah, if
order.
the court accepts it, only then the question of somebody else coming to give evidence.
Usually with
It
an
cannot
order
be
they come.
delegated to another one. That I am a Qazi, a very man of very high position. It's below my dignity to go to the tribunal depose, so I send my LDA. I think that luxury is not available under the law. Number one. Number two, when the Qazi is called on summons to depose evidence on the basis of record, it is not only clerical work to go and produce the record before the tribunal. There is also a requirement under the law of evidence to depose the entries made in the evidence as regards its correctness, as regards its veracity, as regards its meaning. And that only the person who maintains the record can render, not his clerk. And if you say you are paying a cost, we'll question the Qazi why he will charge from someone for appearing before the court when summons is issued. This is an illegal act.
In the notice.
We're going to proceed against his Qazi if he's taking money from somebody for making the records available before the tribunal. It is his legal duty under the law.
So it's, since the burden of proof is upon the OP, so OP has to bear the cost.
No.
So
From
this is-
where do you get this? OP has to bear the cost.
This is the usual practice is going on and.
So we
even-
are questioning the practice.
Practice of convenience, what I said.
Because whenever a
Nothing.
witness, official witness comes, the OP has to bear the cost. And it's written in
And
the
does the
notice.
tribunal provide it?
Yes. Because since the burden of.
Please verify from the tribunal.
The tribunal will not write about the cost
Yes,
part.
yes. I can bring on specifically those notices wherein it's clearly written that OP will bear the cost,
No, it is the
traveling
state
expenses, and
lordship.
the OP will bear the cost, and the signature of the foreigners tribunal is there in the notice. Right now, I don't have. Is there
Yeah.
any ST case of ours we doing before the tribunal? Just get one notice.
No,
Maybe
it-
maybe she's
lordship,
right
it-
also.
Yes, it can be there.
Because she is
because-
very assertive. Must have seen it
Yeah,
somewhere.
sure, I can bring before not only one notices,
No, lordship,
several
the state will
notices.
not bear the cost. This is clear. Because
Then who will bear the cost?
Then who will bear the
the
cost?
cost
Then
has, like lordship said, if some official. If
No,
even
in the-
official
no, what
things
happens,
is-
what happens in a civil case? What is the
Civil
procedure in a
case-
civil case that is going on in the civil courts? When a summons is issued to a witness, who bears the cost?
No, lordship,
Part
in
of on-
civil, in civil courts, I have seen they go themselves, otherwise there is
Yes.
always a fear of a non-bailable warrant being issued, lordship.
CPC
If we get a notice or somebody else, they have to go and appear themselves either through a lawyer or.
And what is the difference between a tribunal and the civil court for the purpose of appearance of witness?
Lordship,
it's-
Same,
tribunal is not-
I think CPC is followed.
CPC is followed, lordship.
CPC is followed.
No, but tribunal, I do not know if tribunals
Uh,
are to bear the cost. We can look into the tribunal procedure.
No,
lordship.
CPC is also there. And even this one, foreigners.
Does the procedure say
There is
they have to bear the cost?
Yes,
If it
we
is
just
yes,
look
then
into
we will
that
accept it. If it
provision.
is,
It's not
if it is so, just find out. If the provision is there.
Because even
And
from
what is
West
the,
Bengal,
and what is the cost that is charged?
lordship, it depends economic mode. If it's from the local area, they will take 500. If it's from the local area. And if it's from far off, like from West Bengal, they are traveling
That is a cost difference.
Yes,
You have to bear.
far off foreigners tribunal as per code. Somebody, may I read those?
And
portions? The foreigners.
and the
tribunal-
Qazi appears to in the tribunal by what means? How does he travel?
Travel,
rickshaw-
if it's like from different
Rickshaw
districts,
or auto rickshaw or car or helicopter, or how does he travel to the tribunal?
that depends, lordship. By auto maybe or by his own
And
vehicle.
is the charge of the auto 500, 1,000 and at these rates? He
So,
cannot make a
no.
profit out of it.
So this is the, even we had to.
And not
Yeah.
the Qazi can charge any legal fees for the purpose
not
of appearing.
fees, the travel expenses.
In the name of travel expense, he cannot charge something more than what is required. That means he is making a gain out of it. If I have to travel, give me an expense of this much, so that I'll spend 50 rupees, go there and rest I'll pocket for myself. That is my fees for
Like
the
if
day.
it's coming from different district, it will be expensive sometimes. Like a case to be proved here in Kamrup Metro and the Qazi has to come from Barak Valley, definitely travel will be more than 1,000.
And let us see where it is.
And power of foreigners tribunal. As per rule 4, the foreigners tribunal shall have the power of a civil court while trying a suit under the code of civil procedure and the power of a judicial magistrate first class under the code of criminal procedure in respect of following matters, namely summoning and enforcing the attendance of any person and
Understand.
examining him or her on oath.
We are also of the same view. So you are
Yes, sir.
exercising power under CPC. So every power under CPC is available for compelling presence. Number one. Now, where is the provision for cost?
Expense part is not there, since the burden, the view of the tribunal is that since the burden is upon the OP.
কিমান দিব লাগে?
The person themselves, they bear the cost. Like the official comes at their own cost. But they charge from the OP.
Madam Ghosh
Yes.
and Madam Verma,
Yes.
Lordship is clarifying,
Yes, Lordship.
in CPC, it is not available, but it is available in the civil code rules. And the procedure is the cost will be deposited by the person who wants that witness to appear in the court or tribunal beforehand. So the tribunal will evaluate what should be the actual cost. And the man will come and that cost will be given to him.
So it's clear now, Lordship, that the proceeding has to bear the cost. Whatever the nominal cost. it is,
Whatever it
yes,
is, the
Lordship.
tribunal will evaluate.
It cannot be exorbitant.
So tribunal take a reasonable view what can be, can be the cost. Require the proceeding to deposit the cost before the tribunal. And this cost will be reimbursed to the witness whenever he comes. Number one. Number two, there is no procedure for a summons, for a person who is issued summons to delegate his appearance to somebody else, be it the clerk, be it the office bearer.
So Lordship, then if somebody who's delegated appears before the tribunal, tribunal should reject that appearance.
Let's come this one.
Yes, Lordship.
And as you say,
Tribunal-
one Qazi is coming from Barak Valley to Kamrup. Tribunal will make a reasonable assessment. What
Of
can
the
be
cost.
the reasonable cost? He'll ask you to deposit it. Otherwise, the witnesses will convert it in a de facto fees in the name of cost.
So if my lord, my friend has pointed out one. This is for someone. No. Summons to the defendants. Service of notice के लिए बोला.
1985 was.
Service of notice.
And come to page 78, this clerk's office bearer, he says that contents of the Kavinnama was not written by Ishaq Ali Chaudhary. I know his handwriting. And this deposition must have been given sometime in 2019 or something like that. 2021. It's a Kavinnama of 1985. Maybe there is a change in Kaji in between. But be that as it may, these issues will not arise if the Kazi comes that this is the record and these are the contents of the record and I'm depositing from the records.
Lordship, the third, at page 78, serial 3 also says, according to certificate at the top of volume book, the certificate should be recorded till 1987, not beyond that. That means the register he was carrying had details up to the, maybe the latest one, because it says should be recorded till 1987, not beyond that.
What does it mean?
The register should have carried records only till 1987, not beyond that. This is what he says at page 78, what Lordship just read out at serial 2, below
So
that
these
is
are
serial
all-
3.
This is all the confusion.
Exactly, Lordship.
So whole thing can be sorted out if the original record is produced, original man is before the tribunal.
Yes.
Yes, what you are trying to show?
Or Lordship may summon the Qazi with the original records here and sort it out.
Who will pay the
Some-
cost? Yes, what are you trying to show from that
Tribunal
book?
may,
No, no, Ghosh is trying.
since this person Ishaq Ali
Yes.
Chaudhary is already there,
Ghosh, you are trying to show something from that book.
let me be convinced first, then I'll be able to, let me.
What is it?
Expenses to be paid in the court.
That is
Hmm.
what Lordship just said, no?
That's what his lordship is indicating. It's a provision of the civil code rules. Although the cost provided in the rules is very small amount because it must be a old rule. Let us take it to be more realistic than the actual cost, whatever it is. The tribunal will assess it.
Let me go through it and I'll submit. the protocol.
No, we don't need any further submission in this. The law is clear. When the rules provide, it is so.
And Lordship has been there, so Lordship, what information has been given is.
We send it back.
Send it back.
Send it back, require
Somebody
the
to-
actual Qazi
Qazi to appear with the
to
original
honor the
records.
summons, come, he'll depose. And the tribunal will make an assessment, what is to be likely cost. The petitioner will depose the cost beforehand to the tribunal. Only thereafter summons can be issued. Summons cannot be issued without depositing the cost.
And Lordship, since this person, Ishaq Ali Chaudhary, the record says he is there. So let him appear in person.
He
Lordship
may
will.
not be holding the post at present because 85.
We are not interested with Ishaq. We are interested with the Qazi.
Records and.
With the
records.
Qazi,
Yes.
who is the
Lordship.
custodian of the records. That's all.
This was discarded only because it was written, date was written in English.
No, that is not the ground. Even
In
it's
the
contradictory. It's contradictory. How can we say only about the detail? The contents of the Kabirnama was not written by him. It is his own office bearer's statement.
Because the
This is
present
what the office
Qazi is-
bearer has said,
because
Lordship.
the old
Madam
Qazi-
Burma, I can say it without banging the table.
No, Lordship, I'm not. I don't do that at all.
It's just like
It was just my finger with you, Lordship.
so no, that doesn't carry any meaning
Lordship,
because this is not the actual person. Why should he take note of his evidence at all? Third, MS Lee Ghosh, learned counsel for the petitioner, also the petitioner Labiron alias Abiron Nessa had been referred to the Foreigners Tribunal number
Number 6.
number 6. 30. Had been referred to the Foreigners Tribunal number 6, Dhuri, for rendering an opinion as to whether he is the person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number FT6 DBB 50 DBB/50/20. What is this? 2019. The tribunal rendered an opinion dated 3/4/2021 declaring the petitioner to be a foreigner. Being aggrieved, district petition is instituted. In the writ proceeding, the petitioner relies on the voters list of, where is that?
Voters list of 1966.
Of
Lordship.
1966
Page 84, Lordship.
of village
Maya Sor Part
Mayasor,
Part 2.
Part 2. In the Bilasipara subdivision of Dhubri district, which contains the name of Haran Mondal, son of Korbor Ali at serial 20, and that of Golabjan Nesa, wife of Haran at serial 21, where both of them are residing in the same house number 12. The petitioner claims to be the daughter of Haran Mondal of the 1966 voters list of village Mayasor Part 2. To substantiate that she is the daughter of Haran Mondal of Mayasor Part 2 village, reliance is placed on a Kabirnama available at page 90 of the writ petition, which shows the name of the bride to be Abiron Nessa, daughter of Haran Mondal of village Mayasor. The Kabirnama had been exhibited before the tribunal through DW7, namely, what's the name of DW7?
Montaz Ali.
Momtaz Ali, who is stated to be a LDA cum office bearer in the office of the Qazi.
Part-time, Lordship. He's a part-time office bearer, not a full-time one also.
The part-time, say in the office of the Qazi. So the Kabinnama itself bears a number, the number 23A 1985, meaning thereby that it's a Kabinnama that must have been registered sometime in the year 1985. It is noticed that the summons was issued by the tribunal to the Qazi, but the Qazi deemed it appropriate to depute the LDA come office, part-time office bearer come LDA of his office for rendering the evidence. The power to delegate of a witness summoned by a court of a tribunal is not available under the law, and neither the law of delegation is applicable in such circumstance. If the summons is issued to a given particular person, it is that particular person alone who can depose as a witness, and not a person who is delegated by the person who is summoned. From such point of view, the evidence of DW7 Mumtaz Ali, who is stated to be a part-time LDA come office bearer in the office of the Qazi and had been delegated by the Qazi to depose before the tribunal, cannot be accepted under the law. MS D. Ghosh, and counsel for the petitioner, states that these proceedings are of a very poor financial background, and it is difficult for them to again bear the cost of the witness to come and depose before the tribunal. We appreciate such stand being taken, that requiring an witness to come and depose before the tribunal and to bear the cost is also a financial burden on the proceedings. How much cost was paid? We'll record it.
That I have to verify with that.
Ask your man how much cost he was paid. This has to be streamlined.
You ask, go and ask.
It
Has
is
to be
stated that the proceedee had paid a cost of rupees, so keep it blank, in order to the Qazi of which village? Qazi of what? Must be
Yes.
either village or something will be there, no? To the Qazi of so and so for appearing before the tribunal.
Office of the marriage registrar and Qazi Doraimari.
Doraimari, yeah?
Yes.
Marriage register office, Doraimari. Full stop.
Doraimari, the senior.
Payment of cost is sought to be justified by referring to which provision of the CPC you referred?
Sixteen. Order 16. Attendance of witness.
Section 35,
Huh?
Section 35 and Order 16, Rule 2.
To Section 35 and Order 16, Rule 2 of the CPC, which provides for
Order 16.
This is order 16A.
which provides that the party applying for a summons shall, before the summons is granted and within a period to be fixed, which shall not be later than 7 days from the date of making application under Rule 1(4) of Order 16, pay into court such sum of money as appears to the court to be sufficient to defray the traveling and other expenses of the person summoned in passing to and from the court in which he is required to attend, and for 1 day's attendance. In other words, the provisions of Order 16 Rule 2 makes it explicit that the amount of cost to be paid to a witness summoned before a proceeding would have to be determined by the court, which in this case would be the tribunal itself. And the determination of the court cost cannot be left to the discretion of the person who is summoned as a witness before the tribunal. Accordingly, in the circumstance above, as we have rejected the evidence of DW7 Mumtaz Ali, who is a part-time LDA cum clerk in the office of the Marriage Register Qazi Omo, and who had been delegated by the magistrate, we remand the matter back to the tribunal to issue a fresh summons to the marriage officer cum Qazi of so and so as to enable the Qazi to appear before the tribunal along with the original register of marriage register, based on which the Kabinnama at page 90 had been issued.
$4,000. So she paid 4,000. 2001 date member was absent, was on.
I had paid a total of 4,000
And next
for
day,
2 dates, in as much as the tribunal member was absent on the first day.
and the second day,
Also, I will take back the legislative work. While issuing fresh summons to the marriage officer cum Qazi of so and so, the tribunal will examine as to what may be the possible cost to be paid to the Qazi, which should be sufficient to defray the traveling and other expenses of the witness in passing to and from the court, that is the tribunal in the present case, for rendering the evidence. The cost to be assessed should be reasonable and actual cost, and it should not in any manner reflect to be a financial gain on the possible witness for appearing before the tribunal. Further, Order 16 Rule 2(3) provides for the scale of expenses, which provides that where the court is subordinate to a high court, in fixing the scale of such expenses, regard should be made to any rules that may be made on that behalf. In the present case, it is stated that the civil court rules do provide for the expenses, provide for the procedure for evaluating the expenses. Accordingly, the tribunal is directed to do the needful to evaluate the reasonable expense that the petitioner proceedee would be required to pay to the Qazi. But why should we pay second time? They have already paid. It is the Qazi who did not come.
Lordship, the summon, as I understand it, page 117 was sent to the marriage registrar, Lordship. He did not come. He authorized somebody to go.
That's what I say.
Yes, so he.
As
will be bearing
this
the cost.
proceedee had already paid that cost,
Yes.
why should this proceedee once again pay the cost?
And Lordship, this order is of 2021. That means this person, this Muslim marriage registrar is still there. Because by
He may be
this-
there, he may not be there. If he's not there, he'll take the money from the other one.
Yes, somebody, Lordship.
This should not be a financial burden on the people also.
Lordship would have to go into too many aspects if Lordship comes into this part of the.
We'll have
expense
to
part.
go.
Yes,
If
Lordship.
law requires, we'll have to go. We cannot run away from our responsibilities merely because we'll have to do
Because
too many
Lordship,
things.
Authorization letter says, I do hereby authorize Mumtaz Ali, come office bearer at Anchalik Qazi office to bring the marriage registrar book in connection with FTK so and so at Gwalpara Dhubri.
No, this we have
on
already
behalf of
rejected.
me. On behalf of me, that means the
This-
summons was
Madam
sent
Verma,
to
why
him.
are you? We have already rejected this one.
No, I'm trying to show lordship that the summons was to him. He did not appear. He asked somebody else to appear. So the cost ought to have been borne by the registrar himself. Because he was summoned in the case, not.
That's
me.
why I say for the second appearance, will not get any cost. But we have noticed that the cost had already been paid by the proceedee to the Magistrate Kazi on 2 earlier occasions. And it is the marriage officer cum Kazi who had acted beyond the provisions of law in not personally appearing and delegating the responsibility to the
LDA.
part-time LDA come office bearer of in his office. From such point of view, for the further appearance, no cost would be required to be paid to the Kazi and
Lordship will direct him to appear.
in the present case, and the tribunal to issue summons to the Kazi for appearance along with the appearance along with the marriage register. But for the general purpose, for requiring the attendance of any witness, it is hereby directed that the tribunal shall procedure the
CPC.
law and procedure laid down in Rule Order 16, Rule 2, read with the provisions of the Civil Code rules for defraying the cost in respect of any witness that is required to appear before the tribunal, meaning thereby that the tribunal will make a true assessment of the actual cost that may be required to be paid, and then require the proceedee to deposit such cost before the tribunal, and thereafter issue the summons, and upon appearance of the person concerned or through any other means to
Reimburse.
hand over the cost so deposited to the witness.
I will pray for a copy of this order so that it can be sent to all the tribunals, lordship.
I have submitted one notice, which is of Kamrup Metro, which says that OP will bear.
No, but that is clear now because the.
So
when
this
say
is,
so,
Yes.
what will happen is from
Yes.
henceforth.
And here, Lordship, one more point is that in 1970, her brother has casted vote along with mother from the same village, and DW2 is the brother of the proceeding, means of the petition.
It is stated that the DW2 is the brother of the proceedee who had casted vote along with his mother, and he is also a witness. If it is so, the proceedee, the tribunal may also look into the evidence of DW2 for rendering its opinion. And upon the Kazi appearing before the tribunal and rendering his evidence, and as well as after considering the evidence DW2, the tribunal may pass a reasoned order. And
Deeply.
a copy of this order, I will take. No, it is important so that all the tribunals can come in uniformity regarding the expense and the summary.
Yeah, I
part,
think
lordship.
these people are exploited by some
Yes.
people. That if you have to go, give me this much of money, otherwise I'm not going.
No, when it comes to the tribunal, they will have some binding on it, lordship.
And it is further clarified that as which provision says the CPC,
CPC, lordship.
that CPC provision in the foreigners thing that
Foreigners
Rule
order,
4.
lordship.
Rule 4 of the
1964 Foreigners Tribunal Rules,
1964 Foreigners Tribunal,
rules.
which page of
No,
this?
Foreigners Tribunal Order.
At page 75, lordship.
In this,
Five.
Page 75, lordship will come.
Hmm.
Powers of foreigners tribunal.
Last sentence. That
Yes,
under
78 in this.
Under clause 4 of the Foreigners Tribunals Order 1964, comma, the procedure that the Foreigners Tribunal shall have
Powers.
the powers of a civil court while trying powers of a civil court while trying a suit under the Code of Civil Procedure and that of the powers of a judicial magistrate first class under the Code of Criminal Procedure in respect of the matters including summoning and enforcing the attendance of any person and examining him or her on oath. As the power under the Code of Civil Procedure and the Criminal Procedure had already been bestowed upon the tribunal, in the event of any non-appearance pursuant to the summons issued, appropriate action under the Code of Civil Procedure and Criminal Procedure may be taken by the tribunal.
It even that
And-
is for issuing a warrant.
And their appearance should not be made subject to payment of any cost or amount being demanded by the witnesses. If any of the proceedee has any difficulty in making the appearance of any witness because of the aforesaid reason of some exorbitant cost being insisted upon, the same be brought to the notice of the tribunal and the tribunals to take appropriate action under the relevant provision of law as indicated above. To whom I take it.
Deeply obliged.
It's a good order, Lordship. It can be sent to all the tribunals because
A
it's-
copy of the order.
yes, everyone is facing this difficulty. চারি নম্বর আমার নহয় চারি পাঁচ আমার
Item 4,
Please, Your Lordship. Your Lordship, matter pertains to death of the petitioner's husband in police custody. On the last occasion, the learned counsel for the CGC took some time to obtain certain information.
Lordship, in fact, Lordship, I have,
That, Colonel
Yes.
Sharma, who is otherwise, what can be done?
Lordship, in fact, I have received a request from the army
I
authorities.
think another law officer is present here today.
No, in fact, it has come through her. They are processing the matter, Lordship. They require some more time, Lordship.
I think that Karbi Anla,
Yes.
Yes.
somebody was picked up,
Yes.
And
Yes, sir.
taken by the army, not taken.
As per the FIR's, Lordship,
Uh,
they were holed up in some place. Initially, the state police had gone. There was a firing. Then an information was sent to the army. Army column came in. Then army was fired upon. In the retaliatory fire, they were killed.
So, no, why we require their presence? These are the matters which took place in which year?
2004.
2004.
Four.
Yes.
It's almost 20 years now.
Yep.
If you want to close it, we'll also observe that whether you are liable or not liable, we are not going into that question.
It's only Lordship was
On the
compensation.
some reasonable compensation, after all, their husband also died.
Yes, yes.
It's not that the person did not die.
Under
Maybe
public law-
police firing, maybe army firing, maybe because of fault of army, may not be because of fault of the army. That in their own defense, they had to fire.
Under public law, Lordship has the power.
So if you agree, we are thinking about agreed,
The local headquarters are.
agreed without implicating any liability.
That is, but
Ah.
again, I would submit Lordship,
Or you want to go for inquiry.
no, Lordship, but ultimately an order has to be passed by this honorable court. But since now they are, the local headquarters are in touch with the central Lordship. They are
Even
required
sometime
sometime they are
Time
required.
we
They are
can allow.
intimated, Lordship.
that
It's,
come forward. There are two ways for you. there are two ways out. Either without adjudicating on any liability as factually the persons have died. Maybe died because of their own fault, maybe died because of the fault of the police, maybe died because of the fault of the army. We don't know. Just as a more humanitarian approach, you pay some compensation, we close the matter here itself.
That is what it.
Ah.
consider.
Or else, if you deny,
That is what you are considering. That is what is being considered.
Ah.
Lordship.
if we deny, we'll have to go into a full-fledged inquiry on this thing. If inquiry after it is revealed that no, the army people are liable,
That
the
is another-
cost will be much more higher, which will be actual. Now we'll be imposing some kind of a, not exactly nominal, but something in the, we can also convince Mr. Doctor to come down for a for some lesser amount. Settle this. And moreover, 20 years have gone by.
Yes, Lordship. That is. Lordship will give some time, Lordship.
Yeah.
Yes, you are already.
Think about it. Which is more suitable and more convenient for you.
Right.
What, get Mr. Chaudhary also. Because again, if it is inquiry, 20 years, people involved will have to call them.
Most of the evidences will be washed off by now.
Evidence may not be washed off. We are not ready to buy that concept. Evidence is washed off. Evidence can still exist. Suppose some eyewitness is there.
Lordship.
That evidence is not washed off.
No.
As long as that man is not, again, that witness is also not washed away. So you can't say. Maybe the bullets may not be available, but other evidence is there. See
Lordship.
how you foresee the whole thing.
In fact, I have talked to them and I have given them the,
But fact is 3 persons died.
in fact, other way, it appears 4 persons died.
4 persons maybe. Yeah. So 3 are before the court.
Yes.
So we are concerned with 3. Certainly.
Lordship, I'll pursue the matter.
Adjourn on the prayer of Mr. Agiri Choudhury, and it will MS, your name?
Major Manisha. Major Manisha, your lordship.
Major Manisha, the law officer, or you have some
OIC
designation?
legal, sir.
It will be given, is present,
Designation
also present before the court.
Okay.
Objection.
When do you want?
Lordship, 4 weeks time, Lordship.
4 weeks. Course will be.
Item 5,
Mr. Sinha.
My pleasure, Lord. Similar here, my lord, the parents of the petitioner are actually residents of
four weeks. Personal offense, sir.
Got the order, no? Actually, I don't know why my name was also put on.
Hmm?
Here, my lord, the parents of the petitioners are resident of Kamakhaguri in.
It's coming for the first time,
Yes, my lord, first time.
no, second time.
That guy did not, I could not attend. Yes,
Firstly, you did not appear.
yes, my lord.
Mm,
The linkage,
mm.
the linkage,
Who is the father of the petitioner?
mother of the father only died in her childhood days. The mother is having the voter list of 1966. And mother was,
Page
yeah.
number.
yes, page is 15. 15 and particular is 16.
1971. Panpoti Dong.
Ponpotia Dom, madam.
Ponpotia.
She was also a employee of that
Panpotia Dong.
Alipurduar Junction under NF Railway.
In which year? In which year she was an employee?
My lord, she died in there in 1993.
No, in
She
which,
employed since 1965.
in which year she was an employee?
All throughout since 1965. Since 1965, she was
And when was this petitioner born?
in the year 2057.
So in 57, the mother may not have been a citizen.
No, mother thereafter got employment. Then linkage I am thinking, madam, on the linkage.
Yes, Madam Verma.
Notice at this stage, lordship, interim. Notice record interim lordship.
Problem.
You were here, so don't start it. Are we any? I said.
Item 6 to 11.
Lordship, I was required to clarify on the tax issue.
Not clarify exactly, once,
Lordship,
no, why we are asking this tax issue, we don't want to adjudicate something on that. Because some issues have been raised that for providing food, etc., NFSA may not be applicable. For giving some benefits under some certain schemes, it may not be applicable. But at the same time, if we consider from the human rights point of view, they are entitled to something, they are at least entitled to food. They are at least entitled to some medical attendance. They are at least entitled to some education. if you strictly follow the rule of that section 3 of that Foreigners Act, they have to bear their own cost.
You have to be.
If on one hand you require somebody to bear their own cost, you also have to provide them with some opportunity to earn some money also. Otherwise, it will be dysfunctional.
Lordship.
One hand you say pay, but on the other hand, you curtail his or don't provide him to earn any money. At moment money is earned, why we are asking the tax? Why do the citizens get the benefit of certain schemes? Because ultimately they are the taxpayers, and these schemes are being financed from the money provided by the taxpayers.
Lordship.
So in public finance, that is the relation between the two. So if these people are also, they'll be required to pay some tax in some form. Maybe they should also get the benefit of the tax, whatever they pay. So therefore, we are asking to what extent they will be paying taxes if they work.
Lordship. So far as indirect taxes are concerned, of course, Lordship.
The GST.
But
Suppose you buy one item in the shop today, you are indirectly you are paying the tax.
as regard the direct taxes, let us take income tax for a moment, Lordship. Income tax act, Lordship, section 4. 4, it does not distinguish between a citizen and a non-citizen. Anybody.
Definitely, otherwise that Vodafone dispute would not have been there.
Lordship, if they fall within that slab
Hmm.
of tax, Lordship, that has to be paid. But at the same time, Lordship, being a migrant or an immigrant, let's say, would that paying of income tax
Hmm.
will.
Wealth tax possibly they will not have to pay because they cannot have any property.
That is so, Lordship. Now here, Lordship, anybody. Section 4 is up. Section 4.
But suppose there is a migrant person who is so enterprising in his work that he is earning a huge amount of money.
Yes, Lordship, the
He
tax.
can. Right
Yes.
to work. Right to work doesn't mean it will be again be classified. You cannot do
Yes.
this work, you can do that work.
Lordship.
Unless, of course, that work itself is a threat to the security of the state or something like that.
Lordship.
So once he does the work, he'll be subjected to income tax. Section 4.
Section 4, Lordship, if you. That does not distinguish between any citizen. Everyone.
So if they are subjected to the income tax, whether they actually come within the relevant slab to pay tax or not is another factor. But they are subjected to the income tax. If they are
Yes.
subjected to the income tax, either entitled to the benefits also.
No, Lordship, because why I am saying income tax is something, Lordship. If an income is illegal also, suppose I earn illegally also, on that illegal money also is tax is payable. But that does not make it a.
No, what we are saying, generally what is there, although there is no quid pro quo in matter of tax, unlike that of a fees. But the public finance concept is
When tax, then
that whatever taxes are being paid, the benefit thereof is being given back
Lordship.
by means of various schemes, etc. So if you are subjected to this tax,
Lordship.
then you are also entitled to the benefits that may flow. But again, this is a very difficult concept. You'll have to take your own call. Because income tax is not the only tax. There are
There are various other
many
taxes.
other kinds of taxes. Many of them they may not be subjected to.
Lordship.
So if you get the full benefit also, that will be a undue benefit.
That is undue.
If you don't get also, it will be it will be overdue benefit. If the other one is undue benefit, this will be overdue benefit
That,
or a due benefit.
that lordship has to examine.
How do you, no, we'll not examine, you'll examine.
Uh,
No, you will frame your order. But we'll like you to take a look into this,
Yes, yes,
to what extent they will be entitled.
yes, lordship.
Hmm.
Otherwise, so far as lordship.
Answer is not wholly no, answer is also not wholly yes.
Yes,
You take your call to what extent. The experts in the government will evaluate it out.
lordship, that,
We leave it to the discussion of the,
that has to be done, lordship. And regarding the other aspects, lordship. land-
property is almost settled.
That is,
That
education, lordship, I am not, because education, lordship,
let them have it.
enlightened.
Hmm.
Lordship.
You
So
don't
far as
know,
Other,
once if you educate them, although they will be illegal migrant without many of the rights, and they happen to stay, this man may ultimately contribute to the country also.
that,
Or he may contribute in the reverse manner also. Both,
It's- I would, lordship, my submission would be, it would be in the reverse manner, because lordship will see. This migration is not simply migration, it is with an agenda. Therefore, it may not be to the help of the country as a whole. That would be my submission, lordship. Because ultimately, we are going to see the change in another 20, 30 years. If it goes on in this manner. And new census 21 under process, as soon as it comes out, it will be very clear. Therefore, that they would be contributing to the Indian society. I would not say I have doubts, I'm sure. And lordship, regarding the census, lordship, I have collected them, lordship. I will make a brief note from 1941 onwards till 2000.
if you put it in a tabular form, we can quote
Yes,
it in our order also.
I have got it right now in a soft copy, lordship. I will
Please
take
hand-
it out.
please hand over that.
And the references which I have given, lordship, in fact, I'm expecting a book by tomorrow or day after, lordship. I will make a note, I'll give the extracts, lordship. Otherwise, lordship, I will go by the submissions made by my senior, lordship. So far as the,
That Khudiram and that one and what is that a one? Some European, no one name is there.
yes,
Sorry.
hey, different code. It's mentioned in paragraph 17. I last time.
So basically, these are the three judgments you relied on, and we also take note of Hormonda Honwal 1, 2, and then Honminlito that Mahahava.
Yes.
These are the 6 judgments.
I'm going this Louis D. Davis of 1991, 3 SCC page 552.
We have referred it earlier.
Yes, I am read into the relevant guidelines.
Mojumdar, we don't need a big note. Can you just in a paper write down the relevant judgments and the paragraphs you have relied on?
Yes.
That much. You don't
Yes.
have to describe anything.
I'll do that. Hello, regarding the property, one submission I would like to make. Your lordship has more or less, we have found that after a person has been declared to be foreigner, he doesn't have any right to own the property. There is one aspect which I would like to highlight. It is careful one. Follow fine.
Yes.
My lord, earlier, this Tera. Earlier, the Foreign Exchange Regulation Act 1973.
Foreign Exchange Regulation Act.
1973.
Which section? Section.
Tera, section 31. my lord. Section 31 contained a restriction about the right to acquire and transfer by a foreigner. my lord.
That they,
Yes. Three things are there my lord, regarding immovable property. One is right to acquire. Second is the right to own the property of which the ownership I have already acquired. And thirdly, the right to dispose of, transfer.
that,
The-
that act relating to land regulation is relating only to transfer.
My lord, well,
It's not for acquiring.
no. We are in this case concerned with.
No,
three
no,
questions.
it is for, why not for acquiring? So he can't,
No,
yeah,
land regulation is for acquiring. I am not on that one. What I am submitting today before your lordship is, we are in this case concerned with three rights of a foreigner. One, after he is declared to be foreigner, whether he can acquire right or not over a property, immovable property
That is in future.
in future.
Ah.
Second, his right to own the property of which he has already acquired. the
Already
ownership.
acquired to continue owning that property.
Yes. Second, which we have been dealing with the second part. We are yet to get a very specific law. Otherwise, we have more or less seen that he doesn't have any right to own the property. And thirdly, right to transfer. Now, supposing, my lord, my lord, there is, I'm sorry, but I have only one extra copy somehow. My lord, I've taken it from Supreme today. This is reported in 2009, volume 5. Andhra Law
Journal.
for what I mean. Page 307, Martinez, Monsanto, Juan versus Union of India. My lord, we were at one stage thinking about the certain rights under the, my lord, Declaration of Human Rights of Individuals, etc. That aspect has been dealt with in respect of a foreigner, my lord. In this judgment, your lordship may kindly go to page 3. I'm just reading few lines from the top, my lord. Mr. Anand Kumar Kapoor, lordship is good, my lord.
Yeah.
Anand Kumar Kapoor, Land Council for the petitioner, contended that Rule 11 and 12 of Registration of Foreigners Rules 1992 are unconstitutional as they violate Article 21 of Constitution of India, and also they are in derogation of Article 25 of the Constitution of India. Learned Counsel submits that as the petitioner came to India to study and practice Vajrayana Buddhism, and that he was practicing the teachings of Buddhism taught by his gurus. Therefore, imposition of the limitation of travel on a foreigner who is holding a valid visa is nothing but an archaic and unreasonable restriction on his freedom to travel within India and abroad, and the same is in clear derogation of Declaration of Human Rights of Individuals who are not nationals of the country in which they live 1985, which was adopted by United Nations General Assembly by Resolution 40/144 of 13 December 1985. It is further contended by the Learned Counsel for the petitioner that the petitioner who is already charged under Section 5 of the Registration of Foreigners Act 1939 and the said Act.
Mr. Mojumdar, this argument is not very attractive and acceptable.
My-
Whatever was argued by that learned counsel,
Yes. And in this
See,
context,
that man may have been practicing some Vajrayana Buddhism, which is very good.
Madam.
Everybody is welcome.
Madam,
But people who genuinely do that,
madam,
for them, there is no requirement to violate any of those foreigners' registration rules, etc.
Right.
People are doing it by complying with the rules.
in this
In
context,
fact,
madam,
Last time I was traveling, a man was sitting next to me in the plane and he started talking. He said that he is a Britisher.
Right.
And he says how much he knows about India. He says for the last some 30 years or something, every year he comes. He works for about 4 or 5 months, comes back here, takes a visa of 6 months. He practices all his religious wishes that he wants to practice. He follows it all the law, goes back, works for another 4 months, again comes back. So whoever is genuinely interested,
madam.
they can do these acts even by complying with the required laws.
Yes, yes.
You don't need to declare an Indian law to be unconstitutional because somebody is practicing some form of Buddhism somewhere.
Absolutely.
These are
Well, two
manifestly
paragraphs,
unacceptable submissions.
well, 2 paragraphs, here some observations are there which will be pertinent in our case. Madam. Page 11, Lordship may kindly see on top. Madam. This is in the context of as per Section 3 of the Foreigners Act, the central government may make an order, etc. Then this on top, madam, page 11.
Hmm.
So far as the contention of the Learned Counsel for the petitioner based upon the Declaration on Human Rights of Individuals who are not nationals of the country in which they live 1985 is concerned, he has placed reliance upon Article 5(1) and 2, which reads as under Article 5 quoted. The next page, madam. Next page, serial number 2. Subject to such restrictions as are prescribed by law. This is what I want to indicate.
Hmm.
Even if it is there, it has to be subject to restrictions. Subject to such restrictions as are
You are
prescribed by
reading
law.
page 11.
Page 12 now, I know.
12.
Yes, page 12, somewhat in the middle, madam, serial number 2, paragraph 2. Subject to such restrictions as are prescribed by law and which are necessary in a democratic society to protect national security, public safety, public order, public health, or morals, or the rights and freedoms of others, and which are consistent with the other rights recognized in the relevant international instruments and those set forth in this declaration, aliens shall enjoy the following rights. Now, A, B, C, D, right to own property alien as well as in association with others, subject to domestic law. Subject to domestic law. Then, Learned Counsel submits that in view of the said convention to which India is a signatory, even a foreigner enjoys rights under clause 2A to D, as well as clause 1A to G of Article 5 of the said Declaration on Human Rights, etc. Now, Lordship may kindly turn to page 14. Page 14, my lord. Last page. This paragraph is very important. The very first line, my lord. If the life and liberty of the foreigner is deprived except in accordance with the provision of the Foreigners Act and the rules made thereunder, this court can enforce the right of such persons. The action of the authorities depriving a person of his life and liberty must be reasonable and arbitrary. However, a foreign national who holds an Indian visa and staying in India without renewal of residential permit granted under the Foreigners Act and the Foreigners Order is not required to enforce fundamental rights under Article 21 of the Constitution of India, inasmuch as the foreigner nationals.
Mr. Mojumdar.
My lord.
Oh, even the court master. Come to Article 22 of the Constitution.
Lordship, can you give me just read a few
No, I
lines
have
there?
read it. So why these are not acceptable as broad-based judgments to
Well,
be,
court itself has said it is not acceptable. Court itself has said.
where?
My lord, Lordship, kindly see. And that's what I want to read, my lord.
Hmm.
Order is not entitled to enforce fundamental right under Article 21 of the Constitution of India, inasmuch as foreigner nationals residential permit is concerned, the right under Article 21 is limited in comparison with the right of a citizen under Article 21 of the Constitution.
Where, which line?
My lord, in the middle, Your Lordship,
Is limited.
limited
Hmm.
in comparison with the right of a person, citizen under Article 21 of the Constitution.
Hmm.
The rights granted either to a foreigner or to a citizen of India are subject to compelling state interests
Hmm.
and permissible reasonable restriction, which includes security of the nation, Lordship, kindly see,
Hmm.
and the constitutional governance. Even those who are not citizens of this country and come here merely as tourists or in any other capacity will be entitled to protection of their lives in accordance with the constitutional provisions, though they have the right to live so long as they are here with human dignity, just as the state is under obligation to protect life of every citizen of this country, so also the state is under an obligation to protect the life of the person who are not citizens of this country. Now, this is important. However, they are subject to reasonable restrictions, and therefore, in case of non-citizen, those rights will be available subject to such restrictions as may be imposed in the interest of the security of the state or other important considerations. In these circumstances, it cannot be said that a personal liberty of the petitioner has been deprived pursuant to procedure adopted by the authorities. So even if 21 is applicable, it is very, very limited, subject to other conditions, including security of the state. For
But
security of the state, if any,
Security is always paramount.
yes, this is what I meant to say. Even 21 is also very, very restricted.
No, we are trying to bring notice to Article 22.
Two.
Protection against arrest and
arrest and
detention in
detention,
certain
that-
no persons and every person who is arrested so and so. Then
Right.
come to 3.
Three.
Nothing in clauses
clause-
1 and 2 shall apply to any person who for the time being is an enemy alien.
Yes.
So life and liberty of a foreigner
My lord.
with the provision that they can enforce site. This is also subject to 22(3) of the
Yes,
constitution.
yes,
So that again depends how you are classified.
yes. Not merely because.
If you
21
are
there,
classified to be an enemy alien,
then.
then again it will be different.
Yes.
Then you don't have some protection of Article 21 for your arrest and detention also.
Yes. My lord, regarding the right to
So
acquire,
these laws are actually so broad-based and
Right.
so circumstance specific
my lord,
that is very difficult to lay down broad parameters of actually what you are entitled and not entitled.
yes,
So we'll just make our endeavor for this class of people,
my lord.
what exactly, to what extent they'll be entitled and to what extent they'll be not entitled.
But this-
Instead of making it a generalized
No,
manner, like using the term foreigner,
my lord.
you use it specifically for this class of people. Then before that, we analyze who they are,
My lord.
how they can be categorized.
My lord.
And once you come to how they can be categorized, what you are entitled.
And the other thing was that FERA regulation that I have,
FERA, that is the.
FERA section 31 was earlier there.
Hmm.
By this FEMA of 1991, that is Foreign Exchange Management Act 1999, FERA has been repealed. But thereafter, in exercise of power under section 47 and section 6, subsection 2 of FEMA 1999, RBI has issued a notification saying that in respect of certain countries, you cannot you can neither transfer nor you can acquire.
To those person from those countries,
Yes.
they will be disentitled to property.
Including Bangladesh and Pakistan. This notification is of 2018. Lordship may straightway go to regulation 9, next page, madam. Prohibition on acquisition or transfer of immovable property in India by citizens of certain countries. 9, Lordship, may kindly say right inside. No person being a citizen of Pakistan, Bangladesh, Sri Lanka, Afghanistan, China, Iran, Nepal, Bhutan, Hong Kong, or Macau, or Democratic People's Republic of Korea, without permission prior permission of the Reserve Bank shall acquire or transfer immovable property in India other than lease not exceeding 5 years. So this much is clear. They can neither acquire nor they can transfer. Suppose even if they own the property, they cannot transfer it. Now, if your lordships hold that they can own also, matter goes. But then so far as acquisition.
No, this is what we are trying to deliberate.
No
No person being they shall acquire
or transfer.
or transfer. So the acquisition of the property itself is illegal.
Prohibit.
So this is a provision
My lord.
of 2018.
Yes.
So now question will come is the retrospectivity or prospectivity of this provision. And as you say, this was earlier followed by section 21 of the
31 of FERA.
31 of FERA.
Yes.
31 of FERA and clause 9 of this notification
Yes. By the
are
RBI.
almost perimeter.
Yes, yes.
Means purpose is
Same.
effect is perimeter,
Yes.
if not the exact word.
Provisions.
So this law existed even
In FERA from 1973.
1973 onwards. So if this law was in force and the person is declared to be a foreigner, say as on 2020 or say as on 2016, can we understand that from the date of declaration, these laws will come into effect? Or by virtue of the declaration, it will have its effect with retrospectivity, that whatever if had done is also an illegal. This is what we are trying to understand.
Once he is declared to be a foreigner, if it through a trial or proceeding, if it is discovered that his presence was from a particular date, his presence from that date itself is illegal.
That's what we are trying to understand.
Yes.
So we'll come back on this issue.
Fine.
Because otherwise, what will happen is, person will come and take the stand that I have acquired this property, say in 1990. And I was declared in 2016. And after 2016, I have not acquired any property.
And
So I am entitled to retain what I had acquired in 1990. How will you answer this question?
my submission is very absolutely, I am very clear.
So
that-
we'll hear you in detail on this issue so that they can also give a reply.
My-
Suppose there will be many number of cases where actually they may have acquired the property
earlier.
a little earlier.
Right.
In the meantime, they are declared. So what effect will it have vis-a-vis section 31 of the FERA and 9 of this new notification regarding the ownership of or the legitimacy of that property
Yes,
on being declared?
yes, will be.
We'll come back and. You got your list.
Lordship, one fixer I have, my lord, that statement given. And lordship, I also told my lord that officer to increase the manpower. And from today, my lord, they have been increasing the manpower. It is a Nagaon district.
No, these are the list you have prepared. Which of the
There are two lists.
new villages they have come?
Lordship, one is, my lord, that.
What is serial number 74?
These are the Dhing town, my lord, these are. My lord, names are not reflected in the my lord 2016. And my lord,
What exactly you
2011,
want, Mr. Henry?
And my lord, the another
How
one is
many,
after.
the number of villages in 2021 is definitely more than what it existed in 1961. Which are the new villages that they came? up?
Lordship, that existing village after 1960, lordship, it was given in another list, lordship. 2011 is the name.
That's the
That is
only
the-
information we want. We don't. You work it out? Is it complete? No.
Not complete, lordship.
It
Then,
needs some more time. Yes.
lordship, sometime now, lord, that manpower has been,
Okay,
I've asked
you-
them to increase the
Yeah.
manpower.
Please do that first.
Lordship.
Right of a person over the land is concerned, my lord. Section 6 of the Assam Land and Revenue Regulation 1886
Yes.
Section 6
Right.
says rights, Lordship has got my lord. Rights which may be acquired over land. No right of any description shall be deemed to have been or shall be acquired by any person over any land to which this chapter applies, except the following. Now, A says right of proprietor, landholders and settlement holders other than landholders as defined in the regulation and other rights acquired in any manner provided by this regulation. B, right legally derived from any right mentioned in clause A. C, right acquired under section 26 and 27 of the Indian Limitation Act, 1877, now 1908. And D, rights acquired by any person as tenant under the rent law for the time being in force, provided that nothing in this section shall be held to derogate from the terms of any lease granted by or on behalf of the government. So this limited right a person acquires, but then I'm only showing this provision only to show that ultimate ownership.
Nothing, what is that? Nothing. You read something that nothing in this provision shall be derogatory.
Yes, provided that nothing in this section shall be held to derogate from the terms of any lease granted by or on behalf of the government. My submission is very simple, Madam. What I am saying is the right a person acquires over land based on any settlement, patta, whatever it is, there is a limited right and ultimate ownership of the land always remains with the government. For this, I am only showing. And the
That is equally applicable for all
For-
citizens
yes.
and non-citizens both.
yes. And Madam, the lastly one judgment of Supreme Court. That is AIR 6, just now I found out AIR 69 Supreme Court. AIR 1969 Supreme Court 843.
AIR 19.
69 Supreme Court 843. Parties names are my lord, Messrs. Players, Leslie and Company Limited versus Miss Violet
What's the name?
Outerlong, Warwickshire.
What is the name?
Very difficult to pronounce. Messrs. Players, PLERCE,
E
then PLERCE,
L E R C E.
then next word, Leslie, LESLIE, and Company Limited versus Violet, etc. Madam. Just in paragraphs, you know.
Mr. Modi, after every case you are referring, it's difficult to pronounce the name of the petition.
It's happening to me because
The other one also,
I am finding it difficult to pronounce. Well, in this case, paragraphs may slightly vary with the actual AIA. I am looking at it from this Supreme today. Paragraph 11 says, my lord, these enactments show that in this country, the government takes by escheat immovable as well as movable property for want of an heir or a successor. In this country, escheat is not based on artificial rules of common law and is not an incident of feudal tenure. It is an incident of sovereignty and rests on the principle of ultimate ownership by the state of all property within its jurisdiction. Private ownership not existing, state must be owner as ultimate lord. As ultimate lord. See collector of Masulipatam versus C. Venkata Narayana, so and so. The rules of English feudal law relating to mean lords are not applicable, and consequently, the Jamindar could not take by escheat the land of a tenant dying without heirs. The right of escheat belongs to the government only. See Rani Sonnet Quair versus Mirza Himmat Bahadur, 1875 to 1870, Indian Miller.
for our purpose, it's. We
Well,
all
I'm
understand.
I'm only-
Ultimately, the ownership lies with the government,
Yes, this for
That
this
is-
only I'm saying.
but. Once somebody acquires the right over a land,
Miller.
either as a proprietor or landholder or settlement holder or in any other manner recognized by law. Question is, suppose a non-citizen also acquires the right in that
Right.
manner.
Miller.
Otherwise, upon being declared, whether that right will continue or it will extinct.
Correct. This is only
But
incident.
otherwise, by default, the state is.
Yes, this is what I'm saying. By default, if that person cannot any longer be held to be the owner, it will revert to the government. This is
For that
this.
purpose.
For that
purpose, yes.
Yes. So far as, my lord, the question as to whether after a person is declared to be a foreigner, it will revert back to the date from which he exists here, or is if he is born here from the date he was born. My answer, my reply will be very simple. Going by the Citizenship Act Section 6A amendment, my lord, only under the present law, my lord, only if a person is found to be under Citizenship Act 6A, my lord, only after a person has been found to have come to India from the specified territory from 25th March 1971. Before that, if he is found, then he is otherwise also not to be deported.
No, he is not a declared foreigner.
Not a declared foreigner. So declared foreigner will be only a person who came to India after 1971, 25th March.
So when there is a definite conclusion by the tribunal that
Ye-
he is a man after 71 and
Ye-
accordingly he is declared.
Yes. So, my lord, my submission will be after he is declared, this declaration will relate back to the date from which he claims to have come to India, because this date anyway will be after 25th March 1971. So it will relate back to that date, my lord.
So declaration will be related to the
Section
Date-
6A of the Citizenship Act,
after 1971 when this person entered the country.
my lord.
So from the very first day he is
Yes.
declared.
Yes.
So whatever act he may have enacted in the meantime, including acquiring property, will also be
Yes.
either null and void or illegal or in whatever term.
Yes,
Right.
it must have been, it must be held to
So
have
it will
been
have
acquired
its-
after
So it will
as a
have
foreigner.
its, retrospective.
Yes. And
The
acqui-
law that the foreigner is not entitled to acquire property will be applicable to him
yes,
from the day he
acquired it.
acquired that property,
Yes. That is my suggestion.
once he is declared.
Yes.
And one more aspect.
I will do that again.
Teaching it will be Mr. Chaudhary will have to address.
এটা তো সরাসরি নিতে এই যে নয় এটা যে লিস্ট বানাবো বুঝলি স্যার এটা লিস্ট অফ পার্সন যে বানাবো এটি যদি করবার আছে এদিকে ভরিয়া ইগো লাগে লিস্ট করবার সবাই লিস্ট বানাবো এলিজিবল হাউস হোল্ড এই মানুহটো এই লিষ্টখন থাকিব নোৱাৰে there is a no question of any right under this act.
Mr. Chaudhary,
Well,
how do you interpret section 3(1)(a) of the Citizenship Act?
Acquisition of citizenship.
Because
every endeavor
Lordship.
will be brought to a knot.
Every endeavor will be brought to a knot if the next generation is
Yes,
gets a right.
Uh,
How do you, what is your submission on this?
Lordship, this, so far as Assam is concerned, Lordship, my submission would be,
No, this is, it's applicable to Assam. 6A does not take it, 3 is not taken out by 6A is only special provisions,
yes.
means in addition to 3. 6A is in addition to 3 for Assam. How do you answer this? So they'll be very happy. So most of these people, they are the second generation one. And most of the adjudications will be null and void if they just take a stand that I was born on so and so date here.
Uh,
And second generation may make a claim, suppose for the first generation on the virtue of being declared to be a foreigner is not entitled to property. Second generation can take the stand that by virtue of being a citizen under section 3(1), I am entitled to inheritance of that property. So you cannot take it away.
Lordship may kindly see, it starts with,
Sorry.
Lordship may kindly take section 3 once again, Lordship 3(1), except as
Except as provided in subsection 2. So
That-
subsection 2 is an exception.
Yes, now Lordship will see 2A.
These are those diplomatic stuff.
Such immunity is not a citizen of India or his father or mother is an, that, of course. Here, Lordship, perhaps Lordship,
How do you read these 2(1) and 2(2) together? Because otherwise everything will be at naught. You just see if the second generation comes say that by virtue of 3(1)(a) or 3(1)(b) also I am a citizen.
Lordship,
So moment he is a citizen, suppose the first generation is declared to be a foreigner, not entitled to everything. Second generation can always come and take a stand that under the law of inheritance, I'm entitled to it. So you just can't take it away. I think this was
Yes.
raised by, I think Madam Ghosh had raised it once, this issue.
Was from West Bengal and she possessed a birth certificate. Yes, I have raised that issue.
No, on the second generation, I think you had or somebody raised one
Not
issue.
second, not here.
This is the second generation people,
Yes, Lordship.
one who were born here. Moment you were born, you are a citizen.
Right to.
So if you are a citizen,
Yes, Lordship.
most of these things you are showing that my father is a citizen, so through him I am claiming. Why do you do all these things? You only thing you show that I was born in so and so date here.
Yes, Lordship.
You were covered by 3(1).
Lordship, I have to look into this. Three to for the rest of India. I want to section 6 specifically for Assam. Okay, 6 to 3 to no. Perhaps Lordship, 6A, 3 will not be applicable to Assam Lordship, because here,
understand how. For the
if we
purpose
see
of
6A,
territory,
Lordship was,
the detected to be a foreigner means.
Lordship,
detected to be a foreigner with the provisions of the. foreign-
6AD. If we look at the second generation, 6AD.
No, this is special provision as to citizenship of persons covered by Assam Act.
Yes,
The person who is covered.
yes,
Is 6A also applicable to the person who is born?
because what? A person shall be deemed to be an of Indian origin if he or either of his parents or any of his grandparents was born in undivided India.
Person shall be deemed to be of Indian origin. No, these are people of Indian origin. Even if they come
So-
from Bangladesh, they are people of Indian origin by virtue of this.
This 3 will be Lordship applicable for the rest of India, Lordship,
Where is that provision?
because
In fact-
6A has been specifically,
And I have heard this argument. Is it adjudicated in any decision? Has it been adjudicated anywhere that for Assam, it is only 6A? And if it is so, what about people like you and me? If 3 is taken out of us, then you say that we are also governed only by 6A.
Lordship,
Where is the provision for Mr. Architecture
D,
in 6A?
D,
D, a person shall be deemed to be of Indian origin.
Right.
If your ideal parents or any of us are born in undivided India. So this will not lead you anywhere. So every person from Pakistan, every person from India is Bangladesh and India, 3 together are covered. Only Sri Lankans are out.
Lordship, perhaps.
So
Lordship,
if only D covers
D and subsection 2.
2, what is 2?
Subject to the provisions of subsection 6 and 7.
So this is also from the specified territory.
Yes, Lordship.
You never came from the specified territory. You means I'm just taking one example.
Huh.
Not that I personally mean something.
I understand, Lordship.
Never came from a specified territory to be included in 2. This is a gray area, Mr. Chaudhary. We have been hearing some arguments from petitioners, although those were not the core issue. Possibly we did not go into it.
I'll
But in
look
one
into it.
case, I think not matter who, somebody raised this issue, I remember. But that matter, some other legal issues were issued involved, it was decided there and remanded back also, but one learned counsel had raised this argument once.
Section 3 vis-a-vis 6.
He says under section 3, I am a citizen. So as we are hearing it on an elaborate manner,
This section 6A,
hmm,
Lordship Mechanic 6A,
hmm,
it says special provisions as to citizenship of persons covered
covered by
Assam
the
Act.
Assam Act. So whosoever is
Persons,
not covered by Assam Act,
yes, for them this section
for them it is 3.
3.
So the person born will say that I am not covered by the Assam Act. He will say, my parents may be covered by Assam Act, but I am not covered by Assam Act. Assam High Court. So section 6A on a plain reading appears to be in addition to 3,
in addition to 3.
not as a substitution of 3. That for Assam only 6A is applicable, rest are not applicable.
And this, Lordship, just see for a moment, I'm not very sure, section 3, A, B, C, after C, Lordship, you kindly see. After C,
Hmm.
last word of C is where. And whether this where both of his parents are citizens of India or
No, for the only for those people on or after the commencement of the
2003. If it is only
That
for
just
C,
except as provided in subsection 2, every person born in India after 26 January, but before 1st of July. Or, no, not or,
not all.
and. On or after 1st July, but before commencement of the thing. And
Right.
either of whose parents
Yes.
is a citizen.
Yes,
So this is born on or after 87. And you were born on or after 2003,
my lord.
both parents are citizen, or one of whose parents is a citizen.
Yes. Only in that case,
No, so they are citizens of India. Only when a person is born after 2003
yes.
and both the parents are illegal migrants,
Yes, ma'am.
then the person will not get the benefit of that one by virtue of 6A. But if one of the parents happen to be a citizen, suppose the illegal migrants comes and marries an Indian citizen. Everything is regularized from the next generation onwards. Answer is there. Answer is there.
Maybe I'm not getting the answer.
But on a plain reading of 3 and 6A, at least I was wondering because on that
Mallory,
submission made on the earlier day, I
Mal-
just happened to.
Hello, one answer I can find is,
Mm,
if your lordship reads C once again, my lord. On or after the commencement of Citizenship Amendment Act 2003,
So
where
now that's why I'm saying every person born on or after, if you go to C, born
Yeah.
in India,
Yeah.
on or after 2003.
yes, now lordship kindly see where both of his parents are citizens, we have no difficulty.
Huh.
2 says one of whose parents is a citizen of India and the other is not an illegal migrant. So if he marries an illegal migrant, he cannot.
Huh.
So,
So, and the other is not an illegal migrant.
yes, so if the
So-
other one is a illegal migrant, even if the one of the parents
One of
is
the
a
parents
citizen,
is a
it doesn't
citizen
help,
and the other is,
not an illegal migrant.
it's a negatively word.
Yes, so it
So
is not helping.
people born after 2003, it is okay.
Yes,
But suppose
I know.
the migrant came in 2001, in 1971, after 71,
After 71.
a man is born in 1974.
Yes,
Are those category of people saved?
no, not saved. But we'll see all these 3, I'm just reading once again. A says born.
No,
on-
let us take one example.
Right.
A person is born in 1974.
Yes,
after the illegal migrant parents came
Yes.
in 1971, means came after 1971.
Yes,
1972,
He
one
was-
illegal migrant couple comes in.
yes.
A child is born in 1974. He will
Exactly.
be covered by A.
No,
Only thing, the child who is born at a later date, suppose that 1974 born
Yeah.
child to an illegal migrant is a citizen by virtue of 3(1)(a). So his child who will be born
before 87.
after 2003 will also be a citizen. Because that man will be an Indian citizen. He will not be an illegal migrant. So when you have put up the cutoff date at 2003, you are protecting a huge chunk of the people, and people born after 2003, between 1971 and 2003, how many years are there? It's almost 32 years.
Yeah.
So that parent who is otherwise an illegal migrant, because of virtue of being born to an illegal migrant parent, will become an Indian citizen by 3(1), and his children will be regularized. They will be continuous. So everybody will be Indian citizen. Why are we having all these laws then? Like of everything.
Possibly, this entire people will be covered by 6A.
6(a). We are reading 6(a) only. 6(a) only, it says that
About the person.
nothing is there. Assam means the territory, the detected foreigner under the Foreigners Act, specified territory, Bangladesh. A person shall be deemed, if he is either the parents, deemed to be detected. Subject to the provisions of section 6, person shall have specified territory. 6(a) is entirely related to people coming from the specified territory. It has nothing to do with people who have not come from the specified territory and are indigenous people. Now, 6(a) nowhere states that the people covered by 6(a) are excluded from the purview of 3. The 3 had been taken away. It's nowhere there.
Subsection 8 may kindly be seen.
8. Is
Subsection
it there?
Yes.
Save as otherwise provided in the provisions of this shall have effect, notwithstanding anything contained in any other law. So,
It says this section. Save as
so
otherwise-
this does not mean
My lord.
that in spite of the provisions of this act, if somebody is governed by other provisions, that has been taken away. Notwithstanding is also in a reverse manner. All it says that whatever special provision are there in 6(a), that is notwithstanding any other. But that does not mean the others are not applicable, if applicable in a given case. That 6(c)(1), the one that you have put in, had it been in place of the 3(1)(c), had it been made applicable from 1971, it is okay. You are safe.
A is creating difficulty.
Hmm.
3(1)(a) is
So, had section 3 been provided in such a way that C exists along with A,
yeah.
then it is okay. It have been, what you are saying is right.
Yeah.
So if either of the parents is only when not an illegal migrant, means if either is the illegal migrant, you are out. Somewhere some wrong drafting it appears.
নিলাম ইচ্ছা করলে ওইখানে গিয়ে আমাদের ফটো করা বা this requires some examination. Will continue.
So Majumdar,
And
will continue at 2 or later?
let it be 2 or let me examine.
Want to say something? Want to say tomorrow?
Take his name along with his parents is there in the year 2015, 93 page number, and his father casted vote in the year 1966, page 73.
73.
Page 73, then 75 also, Lordship. 73 in one village, 66 in one village, but 70 and till date,
Moinal Hawk.
yes,
Page 73
Yes.
is Moinal Hawk.
Yes,
Moinal Hawk is the father.
yes, Lordship,
This is of the year
66.
66, which is
Lord.
Dokhin Halmara.
No, village
No,
is
village the Borof thing, Boroflia Mukhi.
Borfolia Surjomuni.
Borfolia, huh?
Borfolia
Borfolia
Surjomuni.
Mukhi, okay. So now who is
And if we see 1970 voters list, Lordship,
page number?
page number, Lordship, 75.
75. 70. Khopati.
Kopati. And till date, Kopati.
71 Khopati, it is Moinal Hawk.
Yes, Lordship.
So
And
it doesn't matter Moinal Hawk was in Borfolia or not. It
yes,
doesn't matter. As long
yes,
as he
is there,
is there in 1970
70
in Khopati.
Kopati.
Okay,
And
now,
petitioner's name along with his father
Hmm.
is there in the page number 93, Lordship.
93.
Serial number 37,
Serial number
37.
37. Moinal Hawk.
third, Moinal Haq. Then next is his mother, and then his name,
Mother is Sophia.
Sophia Khatun. And then
Mother and
Shah Jamal
Shahjahan
Sheikh.
Sheikh,
Yes, Lordship.
petitioner.
Yes, Lordship.
Yes, Mr. Sharma, go back.
Remand the matter.
This is also of that Khopati.
Kopati, Lordship, Kopati.
It's there.
I have the certified copy of
No,
2000.
no, Madam Ghosh, we also believe people.
Yes,
If you say it is Khopati, it is Khopati.
Kopati, Lordship.
Because if every word we happen to question of the Land Council, where will it lead? Only thing is once detected, then we have
Yes,
to be
yes.
little harsh.
Yes.
Heard MSD Ghosh, and counsel for the petitioner, also heard. So we're looking for. The petitioner Shah Jamal Sheikh had been referred to the
Pointers Terminal number 2, Kamrup Metro.
page number. Where is that order?
Order is at page, Lordship. 17.
17.
Yes, Lordship.
Had been referred to the Foreigners Terminal number 2, Kamrup Metro,
Yes, Lordship.
for rendering an opinion as to whether he entered the state of Assam from the specified territory on or after 25/3/1971, resulting in registration of FT case number 71/2017. The tribunal rendered an opinion dated 9/10/2018 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies on the voters list of 1966 of village Borfolia Hujyamukhi Moni in the present South Salmara Mankachar district, which contains the name of Moinal Haq, son of Kasimuddin, and claims that Moinal Haq is his father. The petitioner thereupon relies on the voters list of 1970 of village Khopati third part, also in the present South Salmara Mankachar district, which contains the name of Moinal Haq, son of Kasmat Ali, at serial 122. It is stated that Moinal Haq of Borofkholia village of 1966 had subsequently shifted to village Khopati, third part. Be that as it may, the voters list of 1970 of voters list Khopati, third part, shows that Moinal Haq was in existence prior to 1970 at Khopati. Petitioner thereupon relies on the voters list of 2015
Yes, Lordship, page
of
93.
also village Khopati, third Khopati, which contains the name of Moinal Haq, son of Kasmet Ali, at serial 37, that of Sophia Khatun, wife of Moinal Haq at serial 38, and that of Shah Jamal Sheikh, son of Moinal Haq at serial 39. And all of them are shown to be residing in the same house number 350. Accordingly, the petitioner claims that the burden under Section 9 of the Foreigners Act 1946 had been discharged. As the 1970 voters list of Khopati third part shows that Moinal Haq, son of Kasmat Ali, is a citizen, and the name of the Shah Jamal Sheikh, son of Moinal Haq, appears along with Moinal Haq, son of Kasmat Ali, in the same voters list of 2015, also of village Khopati, prima facie, it appears that the petitioner may have discharged the burden. For appropriate adjudication, matter remanded back to the tribunal to examine the voters list of 1970 of village Khopati part 3 and that of the voters list of 2015 of village Khopati, and thereupon pass a reasoned order as to whether the petitioner could discharge his burden under Section 9 of the Foreigners Act of 1946. For appropriate adjudication, the petitioner to produce all the intervening voters list between 1970 and 2015, intervening complete voters list of village Khopati for examination of the tribunal. The respondents in the Home Department may also make their own verification, and more particularly whether Shah Jamal Sheikh, son of Moinal, at serial 39 of the voters list of 2015 of village Khopati and the petitioner proceedee Shah Jamal Sheikh are one and the same person. Upon doing the needful, a reasoned order be passed.
My lord, he has exhibited all the voters list, 66, 70, 77, 85, 89, 94, 97, 5, 11, 12, 15, 17, all he has exhibited before the law.
If you have already done, you relied upon.
Yes, Lord.
The tribunal has raised the question from the it is not possible. 17 Yeah, voters list of 2017 also.
Yes,
Voters list of 2017.
yes, Lordship, page 95.
What does it say?
That is single entry voters list. This is not the full voters list where minor
Whatever it is.
Shah Jamal Sheikh, Moinal Haq.
We have noticed that the tribunal in its order dated it date to side above.
Order dated to
9/10/2018 had provided that from the exhibits, it is not possible to ascertain that a person named Moinal Haq, son of Kasmat, of the voters list of 1966, 1970, 1977, 1985, 1989, 1994, and 1997, and a person, Moinal Haq, who is claimed to be father of Shah Jamal Sheikh in the voters list of 2017 are one the same person. If the tribunal could not ascertain whether the two persons are same, it was the duty for the tribunal to call for further materials to have it ascertained and pass a reasoned order, rather than leaving the question open and thereby declare the petitioner to be a foreigner.
2015 certified copy I like.
Produce all the voters list, the petitioner to rely on the complete, rely on the complete voters list. Complete, this not these one word ones.
Yes, Lordship.
Mr. Ali, why the election commission only provides voters list of one man?
They specifically in the form, your lordship mention only the name of the person.
Definitely he will mention,
Yes, lordship.
but when you provide it, why do you provide only one name? Because from one name, it's very difficult to ascertain
Lordship,
a number of aspects. But if you have the complete voters list, lot of comparisons can be made.
If they-
Suppose the other children, the brothers of the father,
Yes.
if they consistently appear in all the lists, it's a good indication that it is the same person.
Lots, petitioner simply writes in the complete voter list of the year, and their department.
You also write the complete voters
that's
list.
what-
You don't have to pay anything extra for that.
Yes,
Then it's very easy to
yes, Your
ascertain.
Lordship, but they have to just apply right now.
Suppose the other brothers of the father,
Yes. It becomes easier
Ah,
to compare. Your Lordship.
everybody's name consistently appear in the subsequent voters list. That means it's an indication it's the same person.
Yes, Lord.
But if it is only one name, you don't know whether that man and this
Yes,
man
yes.
is the same one or
And
not.
similar names appear.
Actually,
same village.
2015 Lordship, 2015, if I would have submitted the certified copy, I would have been declared as an Indian. Since this was only the copy of the electoral roll, it's not the certified copy. Later on, he applied and he got the certified copy of 2015.
Yeah.
This is the reason.
Very done.
Give
13,
This was 13 or what?
12.
Hoi gol. Sahera Khatun.
Yes, Lordship. Very true.
Sahera Khatun, yes, who is the father?
Yes, Lordship. Lordship, father is Asimuddin Mia.
Page number
Page number, Lordship, 66, voters list, page 41.
41.
Father, uncle, and grandmother.
Asimuddin Mia is the father.
Yes, Lordship.
Salimuddin Sheikh is the uncle.
Uncle.
Torif Ban Bewa is the mother. Is the mother of Asimuddin, grandmother. Yeah.
Grandmother.
This is 1966.
41.
Village is Bamadarhat.
No.
Yes.
Parokata,
Hmm.
page
Oh,
41.
Poka Bita. Pora Bita.
Porabita,
Daghor is Bamadarhat.
Porabita, Lordship.
Pora Bita. Okay. Now, which document will show that Sahera is the daughter of Asimuddin?
That is in the record, Lordship.
You need the record.
Yes, in
You take the
the,
record.
and even.
No, you don't have
Panchayat-
to examine
Panchayats.
record. You don't need a permission. You can always request the court master and have it before the matter is called. You take up after some time.
Yes,
You
Lordship.
examine the record in a minute. So if any learned counsel wants to verify the record, you can always make a request to the court master before the matter is called.
item 14 for hearing.
Then if used for the petitioner when the matter is called, list again. If in the event of further non-appearance, appropriate order shall follow.
Item 15,
In spite of
My lord, I am for the respondent. This case is filed by the
state. Yes, Mr. Sharma.
Lordship, as per this indication, Lordship, I am saying, Lordship, so petitioner.
No, this is your petition. You'll have
Yes,
to go.
Lordship, but Somesh Ali, the respondent has died, Lordship. So we want to implement the legal heirs of the.
my lord,
Somesh Ali respondent had died.
died. my lord.
You want to implement the legal heirs.
Let him file an affidavit, Lordship.
It is
by-
stated that Somesh Ali, the respondent in this writ petition, has died during the pendency of this writ petition, and in the circumstance, the petitioner state authorities intends to file an application for substitution of legal heirs.
Yes.
The learned counsel for the respondents to provide the information regarding the detailed particulars of the legal heirs to the learned counsel for the petition.
by way of an-
Otherwise, from where will they get the information? You please provide them. List
Otherwise,
after,
Lordship may file an affidavit.
sorry.
they may allow the silent affidavit, Lordship, by providing legal aid, Lordship.
Who will swear the affidavit?
Oh, yes, sorry, Lordship, sorry. Sorry.
They can give you the information on that basis. You can, please provide the information. How much time you need? Uh, Within how much time will you provide the information?
1 month, my lord.
1 month. Why? Somebody is yet to be
My
born.
lord, I'm going to Hyderabad for treatment on 11 May.
11 is long.
11 for 10 days, I'm going.
11 is long far away. Maybe we'll have the IA before that. Information you call up your
Okay,
clients.
okay, then.
Just
Okay,
take the name of the legal heirs and give it to him.
My lord, tomorrow.
2 weeks.
Item 16,
16 AR Sigdar. Yes, Mr.
My
Sigdar.
lord, here in this case, my lord, the petitioner declared for foreigners of stream, my lord, 66.
Between 66
And
and
he has already registered.
Are we happy with the order?
My lord, she has registered her names. I have interaction with her. And she is saying that after 6 years, my lord, he wants to not to press this matter, my lord.
Not to press.
He has registered, already
Okay,
registered.
on what is the date of registration?
Registered, my lord, on 22nd/9/2017.
So we'll provide that after 10 years from 29/7/2000,
Yes,
she'll be entitled to the other rights as
Yes.
may be entitled. Heard Mr. A.S. Shigdal. Learned counsel for the petitioner also heard Mr. G.J. Sharma. The petitioner Dalima Nisa, who was referred to the Foreigners Tribunal number 1, Bongaigaon, resulting in registration of BGN/FT/ case number 1213/2007, was aggrieved by the conclusions therein that she is declared to be a person who entered the state of Assam from the specified territory after 1/1/1966 and before 25/3/1971. But it is stated by Mr. A.R. Shigdal and counsel for the petitioner that on
22/9/2017.
the petitioner got herself registered with the Foreigners Regional Registering Authority. Boro.
At Bongaigaon, my lord.
Young girl is trying to look through that gap. Ask her to come in. Let her watch the proceedings from inside. Very good. Yes, madam, please come in and be seated. Instead of watching. Yeah. You can take your seat. Yes, keep on. Full stop. In as much as the petitioner had already got herself registered, the petitioner is presently of the view that no further adjudication is required and she is content with the declaration that she is a person who entered the state of Assam between 1166 and 71. As the petitioner had already registered herself on 22/9/2017, as provided under Section 6A of the Citizenship Act 1955, the petitioner, it is accordingly declared that the petitioner would not be entitled to the voting right for a period of 10 years from 22/9/2017, meaning thereby that on and after 23/9/2027, the petitioner would be restored with such a right. Petitioner would also be entitled to all such other rights as may be entitled under the law. In view of the such stand of the petitioner, no further adjudication required. Writ petition closed.
item 17,
17. Yes, Mr.
May I please, your lord.
May Hussain.
My lord,
Sirzam Nisa, who is the father?
my lord, page 23 is the voter
Page
list
number?
of 66 in the name of grandfather and grandmother, lord.
Page number 23, grandfather and grandmother.
Grandmother, lord.
This is NRC,
No, Lordship.
or this is voters list.
Total list of 66.
66 village Gutipara part 3.
Yes, sir.
Who is the grandfather?
Grandfather is Moyan Sheikh.
Moyan Sheikh, grandfather.
Grandmother.
And Majiran is the grandmother.
Yes, sir.
Who is the father?
My lord, page 29. Grandmother and father's name appears. Sajiron Beba and
29.
Siraj Ali.
Just a minute. Gutipara. It's 1985. Okay. And who is the father? Siraj Ali.
Siraj Ali Lordship.
Siraj Ali is the father. Okay, now where is between
My lord, page 40.
Sebzum and Siraj?
Page 40 Lordship Kabin.
40.
Yes, Lordship. Serial number 2 Lordship.
What is what? Kabin Nama?
Yes, Lordship, Kabin number.
Hmm. Yes, Mr. Sharma. Third Mr. My বেশি হব নাকি তিনটা মান পড়ি দিছো চেঞ্জ করে দাও one only you take this one next one heard Mr. M.I. Hussain and counsel for the petitioner. The petitioner Serzun Nisa had been referred to the Foreigners Tribunal
120.
Foreigners Tribunal number 6 Dhubri at Bilasipara for rendering an opinion as to whether she is same thing, whether she is a person who became resulting in registration of case number FT 6DBB/203/201E. An opinion dated 11/6/2019 had been rendered by the tribunal declaring the petitioner to be a foreigner, being aggrieved as that petition is instituted. Full stop. The petitioner relies on the voters list of 1966 of village Gutipara part 3, Bogoribari in the Dhubri district, which contains the name of Moyan Sheikh, son of Kamuldia, at serial 118, and that of Majiran Bibi, wife of Moyan, at serial 119, where both are residing in same house number 86. Petitioner thereafter relies on the voters list of 1985 of village Gutipara part 2, containing the name of Sajiran Bewa, wife of Moyan Ali, and that of Siraj Ali, son of Moyan Ali, at serial 197 and 98 respectively, where both are shown to be residing in the same house number 4. It is stated that Majiran Bibi, after her death, although ought to have been referred as Majiran Bewa, had been incorrectly shown as Sajiran Bewa, wife of Moyan, but it is actually one and the same person.
Lordship, actually, in vernacular Sajiran. In particular, it is Sajiran. My typographical page 66. My typographical error, Lordship. Vernacular is Sajiran.
Is Sajiran? Then why didn't you point out? Majiran likhibo, Sajiran likhibo, and you correct it. Okay, likhibo. Sajiran Bibi is now known as, after the death of her husband, Majiran Bibi is now shown as Majiran Bewa, which is acceptable under the law governing the parties. To whom the notice is issued, Sarjan or Sajiran?
Lordship, Sajiran is the grandmother, Lordship. Serzan is the petitioner, Lordship.
But Serzan is the
Serzan.
petitioner of Sarjan, nothing yet. The petitioner also relies upon a Kabin Nama which contains the information that Bosamat Sarjan Nessa is the daughter of Sirajuddin of village Gutipara and accordingly claims to have discharged a burden that Siraj Ali of the voters list of 1985 of village Gutipara part 2 is the father of the petitioner and also accordingly claims to have discharged the burden under section 9 of the Foreigners Act 1946. A question would remain as to whether Sirajuddin of village Gutipara and Siraj Ali, son of Moin Ali of Gutipara part 2 are one and the same person. In the circumstance, matter remanded back to the tribunal to examine the voters list of 1966 of village Gutipara part 2 in the Dhubri district, as well as the voters list of 1985 of village Gutipara part 2 containing the name of Siraj Ali, son of Moyan Ali. And also as to whether the Kabinnama, which provides the information that Sarjan Nessa is the son of Sirajuddin of village Gutipara, কি করলো? To examine the examine the voters of 66 and 85 and also to Kabinnama, which contains the information and arrive at its conclusion as to whether Sirajuddin of village Gutipara of the Kabinnama and Siraj Ali, son of Moyan of the 85 voters list of village Gutipara part 3 are one and the same person. And also as to whether the information contained in the state voters list do establish that the petitioner is a citizen of India. Accordingly, upon doing the necessary examination, a written order be passed. The respondents in the Home Department may also make their own verification as to whether Sirajuddin and Siraj Ali are one and the same person. The petitioner to also examine the marriage officer cum Qazi who had issued the Kabinnama at page 40 annexure 11 of the writ petition and require the Qazi to depose on the basis of the original marriage register, to depose as regards the entries made therein on the basis of the original marriage register.
Examine lordship.
Sorry,
Is examined.
is examined.
Lordship, page 113.
Qazi
Yes.
himself or again that
Qazi
one clerk,
Kazi
I
lordship.
shall ask you. Qazi,
Yes, lordship.
to also take note of the evidence of the Qazi. So, examine to to also take note of the
This
Qazi.
discussed in case 20.
Upon doing the needful, reason order be passed.
Lordship, it is Gutipara part 3.
Sorry,
Gutipara part 3, lordship.
part 3.
Yes. Obliged.
Item 19,
There is already a few Borguia. Yes.
Lordship, the petitioner, she was born in village Jhaukati in the district of Kuch Bihar, Lordship. Kuch Bihar,
Coach Bihar,
Lordship.
19, Naiman Bibi.
Her father's name appeared. in
Where
the-
is this? Where does the name of father appear?
Lordship, voter list of 1966, page 18, Lordship.
Page
18.
18. আট নম্বর তুফানগঞ্জ
Not
টপ
yet.
হিল বিধান হওয়া নির্বাচন ক্ষেত্রের চূড়ান্ত ভোটার তালিকা 1966 সালে প্রস্তুত পশ্চিমবঙ্গ সরকার শেখ নইমুদ্দিন
Lordship,
হু ইজ শেখ নইমুদ্দিন
father, Lordship.
father and
Lordship, even during.
and
inquiry-
which document will show that Noiman Bibi is the daughter of
Lordship, one legal head certificate, Lordship, page 31, Lordship.
page 31. Legal heir certificate.
Certificate, Lordship.
Who had issued it?
Lordship, Gaon Pradhan of Balapur, village Balapur, Lordship.
Certified at low
Gram
in, but this is not good enough.
Lordship, her own brother adduced evidence, and Lordship kindly,
Page number.
Lordship brother.
See,
Lordship,
when
page
one
50,
certificate issued by one person or the other, unless the issuing authority
Adduced evidence.
is a person who holds some public record from where the certificate is made, or he has some personal knowledge about the existence of the fact, these certificates have almost no value in evidence. Okay,
Lordship.
so
Lordship,
you
page
just cannot
58.
rely on this. So where is the brother? Page number?
Lordship, page 58, Lordship,
Page
58.
58.
Eight.
Okay.
That OP is my.
Iman Ali, son of Noimuddin Sheikh of village Jhaukuti.
Lordship,
So this is of village Jhaukuti.
Lordship.
Jhaukuti, yes. Jhaukuti, Tufanganj. Was he cross-examined?
Lordship,
Which page?
Lordship, page 61, Lordship, page 61, Lordship. That is the type copy, Lordship, translated type copy.
Has this lady inherited any property in Tufanganj? Say
Lordship,
mutation.
regarding land documents, I have,
That will be a very good
Documents, Lordship.
material for you.
Lordship,
Any Yes, Mr. Sharma. Who's Iman Ali, son of Noimuddin? He says so.
There is a lack of documented
Mhm.
evidence, Lordship.
See, this Iman Ali has produced a number of documents. Ration card, Khaitan. Inheritance certificate. See, he has also exhibited one inheritance certificate, the one she is relying on, that one particular page.
okay, page 60.
Page number 60. But he is not cross-examined in any way that you were given a wrong document, these that. Your name, madam, Bok,
S Das, Lordship,
Huh?
S Das,
For
Yes.
cross-examination.
yes?
Das.
Das, oh, sorry. That MSS Das. The petitioner Naiman Bibi had been referred to the foreigners tribunal number
Lordship,
to Dhubri for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number FC 30/AGMN/2017. An opinion dated 31/8/2019 had been rendered declaring the petitioner to be a foreigner. Being aggrieved, the writ petition is instituted. In the writ proceeding, the petitioner relies on the voters list of 1966 of village Jhaukuthi, police station Tufanganj, district Kuch Bihar, in the state of West Bengal, which contains the name of Sheikh Naimuddin, son of Holai, at serial 160. Is there any voters list together of Sheikh Naimuddin and Iman Ali?
No, Lordship,
Why don't you bring that?
Lordship.
It will be,
Yes, Lordship.
the petitioner relies on the evidence of Iman Ali, son of Naimuddin Sheikh of village Jaukuti of Kochbiar district in West Bengal, wherein he had deposed that the petitioner proceeding Neumann Bibi is his sister. In the evidence, the Iman Ali also exhibits an inheritance certificate issued by the Pradhan of Balabhut Gram Panchayat, which contains the information that the legal heirs of Sheikh Naimuddin are, amongst others, Iman Ali being his son, and also Neumann Bibi, his daughter, along with the other sons and daughters. In cross-examination, the state authorities had not made any suggestion or had put any question which may rebut the evidence rendered by Iman Ali, son of Sheikh Naimuddin. But we have noticed that no voters list containing the name of Naimuddin Sheikh and that of Iman Ali has been produced before us. In the circumstance, matter remanded back to the tribunal to enable the petitioner to produce any voters list of village Jaukuti which may contain the name of Naimuddin Sheikh and that of Iman Ali in the same voters list. The respondents are also given the liberty to cross-examine Iman Ali, son of Naimuddin Sheikh, as regards the evidence rendered that the petitioner is his younger daughter, is his sister, and as also as regards the inheritance certificate, which contains that both Iman Ali and Neumann Bibi, amongst others, are the legal heirs of Naimuddin Sheikh of village Jaukuti. If there is any document which shows the petitioner had inherited the property of Naimuddin Sheikh, the petitioner would be at liberty to produce the same before upon such materials being produced, the tribunal may pass a reasoned order.
State they have not cross-examined, but the question was put forwarded by the tribunal, Lordship.
So let him cross-examine.
Lordship.
Item 20.
Yes. Abdul Bashar, who is he?
Yes, Lordship.
I don't have the copy.
66
I
and
don't have the
70.
copy.
Sorry.
I don't have the copy, Lordship. Sorry.
Adjourn on the prayer of Mr. G. Sharma and to be listed on so and so.
আগোটা করে দিলে মসজিদে
You can Give him a copy if he wants. He doesn't have the repetition.
21 and 22.
Johura Khatum and Shahjahan Ali. Why they are together?
Lordship, for the issue is same lordship. Now the two certificates are given.
No, Shahjahan and Johura, why are they together, listed together?
I don't know, is coming from beginning because lordship, the from same area lordship and two certificates lordship, they relate lordship. And perhaps they are sent to by verification lordship by the.
No, why should we hear two repetitions together?
May not be necessary.
Lordship, earlier occasion, your lordship asked for a report from. Commissioner SP Nulbari,
Inside border as required by the order is approaching.
and as per report, lordship, it was already submitted before the court, lordship. Lordship.
You filed the affidavit.
No, not yet.
The affidavit be filed by the Superintendent of Police Border Nalbari as required by the order 13/2020. List on so and so.
For the to be given lordship, and so far I have asked lordship, my person may submit one thing lordship. The inquiry lordship, the what is, he has submitted lordship by the SP lordship, that is not done by the properly lordship, still lordship. I have my client asked to the secretary lordship. Secretary says only border police lordship, only one day asked him over telephone that I am going to you. Thereafter he did not go there. And suddenly this
You
report.
filed your
Let
affidavit.
us file the affidavit, lordship, let him.
If you don't file, next day he'll be ordered to be personally present. Tell him.
Yes.
Let him complete the inquiry, file. We are giving you 2 weeks.
Yes.
After 2 weeks at a date.
16th.
16th May.
Yes, lordship.
Pending item.
Ask the superintendent not to take our orders so casually. If he is required to do something, he has to do it.
Item 13.
This lordship, 66. Father of the petitioner has casted vote. 66 is father, uncle and grandmother lordship. Page
number.
41. And 70 also father, uncle, grandmother, mother.
Asimuddin Mia.
Yes, lordship, father.
Asimuddin father.
Yes, lord,
Solimuddin uncle.
uncle.
To-
Tofi-
Tofiron grandmother.
Grandmother.
Uh,
Then 70 voters list,
Hmm.
page 43. Asimuddin Mia, father, uncle, grandmother. Then mother is there, Falaton Nessa. 122,
This is your 1970.
70 voters list.
Asimuddin is the father.
Yes, lordship.
Now petitioner is Sahera.
Yes, lordship. Sahara in 85, page 15. But link document is not annexed along with the writ petition. It's there in the record, lordship. Is at page 50 of the record.
What do you mean by link document?
Means that so and so is my father. Otherwise, she did not cast vote prior to her marriage, so her name is not enrolled along with.
Yeah,
her.
very well. So bring some other evidence.
Brother has adduced evidence, lordship.
Who is the brother?
Brother is page 34.
So who is the brother?
Brother is lordship.
Where is the voters list of brother and father together?
Abdul Rahim Mia. Mother and brother is together, lordship.
Where, which page?
Page 46.
Page 46.
Yes, lordship.
It is different.
Yes, village is different. Abdul Rahim Mia has casted.
Abdul Rahim Mia.
Yes,
Abdul Rahim Mia is the son of Osumuddin.
Osimuddin, phonetics, Lordship. Asimuddin, Osimuddin, O-N.
Osu. Osmuddin.
Yes, in my name also, sometime A, sometime O. Pronunciation will come little different.
Your which name?
My name, Debasmita, Deboshmita. So phonetics, little it differs. So this is, I will say it's true phonetics.
Very well. देखिए गाँव बिल्डे देखा तो ये लोगों पे हैं से
Yes.
how the two villages merge with each other.
If my learned friend helps, then it will be easy, Lordship.
Will become one village.
No, shifting will be the upward and downward voters
Okay,
list.
Mr. Ali. The Election Commission to produce the downward and upward voters list of 19 of village Pora Vita in the Dhuri, in which district?
It's
In
Dhuri
in
district.
the present South Salmara Mankachar district. And Simlabari also under the present South Salmara Mankachar district. In order to examine the contention of shifting that took place in the year
1990.
1990.
He had stated in the written statement.
List after 2 weeks. Any matter?